Welcome back for Chapter 2, where we're going to dive into the trial process in the United States. Now, some of you I know are from other countries, and you may have had other experiences, but the focus of this course is the U.S. and our court systems, so that's where I'm going to direct my attention. Feel free in class, though, to bring up examples of how our process may be different from yours, because it's really helpful for all of us to understand, especially as business moves more and more international. All right, so let's dig in. All right, first thing to understand is that the court is just, they call it a tribunal, but it's just the place you go to have your case decided. And the court is going to hear evidence, and then it's going to decide cases. Now, if it's just a judge trial, then the judge will hear all the evidence and decide the law. If you have a jury, because one of the parties has requested a jury, then the jury will decide the facts after hearing the evidence, and the judge decides the law. And so this is a really important distinction. Juries will never, ever decide what the law is. That is always the prerogative of the court. So when you see a jury comes back and finds that the defendant was guilty, the way that they're able to do that is they're deciding based on all the facts, based on all the witnesses, all the forensic evidence, things like that has been presented to them. And based on the jury instructions, which are the law as established by the judge for that case, then they match the facts up with the law, the jury instructions, and reach a determination for whether there's guilt or innocence. So that's how that plays out in most of the jury trials that you would have seen either on TV or in a movie. So it's still accurate, but that's where the law is being decided. So they will provide remedies when a crime or a contract breach or a civil breach has occurred, and they'll issue injunctions when equitable remedies are the right response. So remember, money is what makes everything better in the United States, but equity steps in when money's not going to be sufficient. So one of the best examples I could give you is imagine someone decides that they want to knock down the White House, and they're going to just buy up all that space, all those acres down in D.C., and they're going to put in a hotel or something. Well, if the court goes through the whole trial process to decide whether or not they can actually, this company or consortium can purchase the White House and tear it down, in the process, the White House will have been knocked down. And you might go, who cares? What's the big deal? Why it matters is that the White House is historical. It's filled with all this history, all these events that have happened there, being burned in the War of 1812, being rebuilt, being painted white. I mean, all those things, all the people who've lived there and have stayed in the different rooms, all of that's lost and can never be replaced. And so that's why we have things like National Historic Registries, because we've said there are some buildings that once you knock them down, you can never recapture the intrinsic value, the historical value. Another example would be if someone wanted to buy like a Van Gogh painting and they wanted to paint over it and destroy it. Well, once the painting's destroyed, it can never be recaptured. That's one of the tragedies of World War II and Hitler collecting all of that art and destroying so much of it, is we can never replace it. It is gone forever. So in that type of situation, someone could step in, make the argument to the court that while we're trying to decide whether or not this contract is valid or whether he has the right to destroy this, if he destroys it in the intervening time, we have lost and history has lost. And so that's where money alone is not going to be sufficient. And so equity injunction to stop something from happening is the better result. All right, so there are different types of courts. Jurisdiction is a term you will want to know. So I'm going to try and make these different types of jurisdiction understandable. If it's still confusing, please bring it up when we're in class together. Subject matter jurisdiction relates to the subject or the area of the case. Original jurisdiction just means that's where the case is starting. So district courts at the federal level are always original jurisdiction. Every once in a while, the Supreme Court is, but that's when states are suing each other, or there's some type of, we're suing a government. And then general jurisdiction is a very broad jurisdiction. Okay, so I'm going to try and give you some examples or some stories to help you remember this. The court I worked at was the Court of Federal Claims. So it had unique jurisdiction in that the United States government is always the defendant. So if you want to sue the federal government, the Court of Federal Claims is one of the district courts that you can go to. But if I want to sue Purdue, I can't go to the Court of Federal Claims because they're not the federal government. It's a branch of a state government. So because of that, it had limited subject matter jurisdiction because it had to involve subjects that where you were going to be suing the government. So it was takings, the government taking property. It was employment where you had worked for the federal government and felt like you'd been fired or hadn't been promoted properly. It was contract disputes with the federal government, treaty disputes with the federal government, so like Indian issues, things like that, and tax disputes. Now, with tax, you can sue the government or the government can sue you in district court. Just a general run-of-the-mill district court like the one up in South Bend or Hammond, and down in Indianapolis. Indiana has 2 federal district court jurisdictions. You could sue in the Court of Federal Claims, or you can sue in tax court. Tax court is subject matter jurisdiction because it is restricted just to taxes and disputes with the IRS. So some state examples. The circuit court downtown it has original jurisdiction for everything. It's general jurisdiction. But it also has subject matter jurisdiction because it is the only court in Tippecanoe County that does probate. So when I do adoptions, like I have a couple coming up in August, and I'll have some after that, I go in front of the circuit court judge because he is the only one who can hear adoptions or estate disputes or guardianships. Both circuit and superior court has original jurisdiction for a bunch of other things. They can hear lots of crimes, contract disputes, and family law type of disputes. But superior court 3 can only hear things related to juveniles. So it's juvenile criminal matters, children in need of services, and then other issues related to children and child support and things like that. So that gives you a couple more examples. Bankruptcy court would be subject matter. It's limited to that specific area. All right. And then appellate jurisdiction is if you don't like what happened at the court of original jurisdiction, so the district court, then you can appeal to the appellate court who's going to review the findings of the lower court. Why this matters is if you don't get the facts, the right facts in at the lower court, then they're not going to come in at the appellate court. You can't have new evidence presented except for very rare circumstances. And then that appellate court is going to affirm, which means they agree with the lower court judge. They're going to reverse that judge, or they're going to remand for further proceedings. So the federal court system, this is an example of, I'll try and blow this up so you can see it a little better. There we go. So you've got at the top the Supreme Court, which is the ultimate judicial authority in the United States. Then you have the Court of Appeals, and we have 13 of those in the United States, plus the Federal Circuit. And then there are the federal district courts, which every state has at least one federal district court. And the best way to think of this is that they're organized based on congressional districts. So basically, you're going to be pretty close. So if, like, Texas has 57 some congressional seats or electoral votes, so they've probably got about 40 judges. So it's kind of a rough way to look at it. Nebraska only has 3 congressional seats. They're not going to have, I don't even think they have more than 1. They might have 2 with Omaha and Lincoln. And then you've got the specialized courts below that, the Bankruptcy Court, Tax Court, U.S. Claims Court, where I worked, Court of Military Appeals, and Court of International Trade. All right. And I'm not going to go through all those slides. You'll have them. But the state court matches up almost exactly. Now, every once in a while, the terminology is a little different. The best example I can give you of that is in New York State. The Supreme Courts are your low court. I don't know why, other than it's New York and they just want to be different, but they've kind of flipped it on its head. But you're going to have general trial courts. Like I was saying, here in Indiana, those are called superior and circuit courts. And then you have specialty courts. So that would be probate. When you go, I just lost the term, but like when your landlord sues you, small claims. When you go into small claims court, that's specialized because it is restricted to disputes that are below a certain dollar amount, and that way you don't need to have attorneys who go with you. Then you've got the appellate courts. Now, when it comes to crimes, you always have a right of appeal, but when it comes to civil matters, you don't automatically get to appeal your case. And then you've got the Supreme Courts. And usually that's going to be the final place unless the U.S. Supreme Court decides that there is enough of a dispute between the different states on how an issue is being handled, and then the Supreme Court will accept jurisdiction. All right, so who are the participants? Here's some just basic terminology that you need to know. Plaintiffs are those who initiate the court proceeding. If you are in civil court, it's going to be a plaintiff. If you're on the criminal side, then it's going to be the prosecutor. Here's one of the things that books and TV shows often get wrong, and it drives me crazy because it's so easy to get it right. The initiating party on the criminal side is a prosecutor. It's a state's attorney. It's a county attorney. It's a government employee. They're not the plaintiff. The plaintiff is the terminology on the state side or on the civil side. Whoever's being sued is always the defendant, though. So it's a criminal defendant, it's a civil defendant. But on the initiating side, it's going to be the plaintiff or the government if it's a crime. The judge is who's going to manage the case. They're the one who's going to decide what the law is. The jury are just those citizens who are sworn to make a determination and reach a verdict. This is one of the very few things that our country requires of you as a citizen. So at some point, you'll be called for jury duty, and it's your kind of civil obligation to go. And then attorney-client privilege is a legal term that just means that when a client is communicating with their attorney, then their communication is protected unless they then go around and tell somebody else. But you can protect and keep confidential those communications, those things that you tell your attorney. But if you then turn around and tell somebody else that same information, then that confidentiality is breached and it no longer applies to those conversations and that information. All right, conflict of law is the idea of what law is going to apply in a situation. So if you have a contract dispute, you can set inside the contract where the lawsuit can be brought and which state's law is going to apply. In a car accident, it's usually going to be where the car accident occurred because that's where your evidence is going to be, that's where the witnesses are, and so that's where the lawsuit has to be brought. You can have some arguments. Sometimes you get to choose where you're going to file. Normally, though, when it comes to conflict of law, there's going to be a pretty defined procedure that lets you know how you're going to figure out whether you're using Illinois or Indiana law. All right, a lawsuit. So you're probably going to want to know what these steps of a lawsuit are. A lawsuit is started by filing a complaint. And that complaint, like I said earlier, can be pretty detailed if you're in certain states, or it can be pretty straightforward if it's a notice pleading state, where basically you're just putting the defendant on notice that the plaintiff believes they have a cause of action or a claim against the defendant. That complaint then has to be served. So in TV, you'll often see this done by a sheriff's deputy showing up and, knocking on the door and, banging and saying, you've been served your papers. Or you'll see someone's been hired and they show up at the airport, and as the person's getting off the airplane, they shove papers at them and say, you've been served. Most of the time, it's done by mail. So it's not always that dramatic. I hate to break it to you, but law's not always that exciting. Now, I did have an adoption this summer where I thought I was going to have to serve a service member. He was in the military in Japan. And under the Hague Convention, I was going to have to serve him personally. But we were able to get him to acknowledge that he'd received things, so I didn't need to do that. But there are circumstances where you're going to have to serve someone in that very personalized way. But most states and most laws allow for service by certified mail. And so that's what we do 90% of the time, if not more. Then the defendant, once they receive that complaint, whether it's been served by mail or by a person, they have 20 days to respond with their answer. This can be extended and often is, but there are very strict timelines, and this is the procedural law that has to be followed, or the defendant is going to lose their right to respond. And what you're going to do is you're going to respond in one of three ways. You're going to say either, and you go line by line through the complaint. I mean, you'll literally go line by line through the complaint. And you say, I agree that information is correct, or I have insufficient evidence or knowledge to agree or deny, or you deny. And you have to do that for every allegation that's contained in the complaint. The other thing that a defendant can do is they can file a motion to dismiss, which basically means that the plaintiff's attorney didn't follow the law or doesn't know the law, and that's never a good thing. Or they can file a counterclaim that says, I'm going to sue you back because we were hurt as well. Then you'll get into discovery. Most of the time, we would start with interrogatories, which are written questions, and a request for production of documents, which is where the parties exchange things like emails, paper. And nowadays, everything's done electronically, so you'll get a flash drive or compact disc filled with the evidence. It's not like you get boxes and boxes. Now, when I clerked at the Court of Federal Claims, fortunately, this wasn't my case, but there was a tax case involving a large oil company and the United States government that literally took up an entire wall with 5 bookshelves with banker boxes filled with evidence. And it was probably a good 20, 30 feet of bookshelves, just crammed with evidence. Fortunately, my cases had smaller, it was more like a couple binders of evidence. But nowadays, that would all be done electronically. And then once we've got the interrogatories, once we've got the documents, then we'll do depositions if they're necessary. And that's just like you're testifying in court. It's taken under oath. The judge is not there, but you can get the judge involved if you need to. It's never a good idea, but it's an option. And it sometimes will be taken by video if there's any concern that you won't be able to find the witness, or if they're ill and they may die before trial, then you'll do a video deposition. And sometime in the discovery process, we'll also move to the motion for summary judgment, which is a Rule 56 motion. And basically, it tells the judge there are no material facts in dispute. And because of that, we don't need a trial. We don't need a jury. You can decide the case today solely on the law. And this is a very useful tool in trials because if it doesn't take care of it and completely eliminate the dispute, it'll take away some of the counterclaims and some of the extra charges. And so it can really narrow down the trial, which then is less expensive. So I did a lot of summary judgment motions. And then you'll designate your witnesses. The idea that there are any surprises when you get to court is just crazy because we've had to identify our evidence, we've had to identify our witnesses. So each side knows pretty much exactly what's going to happen at trial before it starts. So if you've ever watched Perry Mason and those surprise witnesses at the end, that just really doesn't happen. It is possible. There are limited circumstances where you can do that, but it's not normal in an average trial. Then you'll select a jury. You have opening statements. You present your evidence. Here in Indiana, if I'm the plaintiff, I'll bring my first witness and I'll examine them, a direct examination. And then the other attorney will get up and he'll cross-examine. So he'll ask his questions. And then I can redirect. And then they can recross. And then I can redirect. So there's not really a limit unless the judge just loses patience. But normally they won't do that. So you go back and forth until all the questions are done. And then at the close of the plaintiff's case or the prosecution's case, the defendant will move for a directed verdict, basically alleging that the plaintiff has not met their burden of proof, which at a civil case is a preponderance of the evidence, but at the criminal, it's a reasonable doubt. And we'll talk about that more in class. I've never heard of a judge actually granting this at that stage. Usually they'll take it under advisement. Then the defense makes their case, and then you have closing arguments at the end of that. And you can move for a mistrial. Those don't happen very often outside of Hollywood. And then the attorneys have worked with the judge to create the jury instructions. Remember, that's where the law is decided, which law is going to apply and what it means. And that's given to the jury, who then reaches a verdict. The other thing to keep in mind is that if there's no jury, then the judge is the one giving the verdict. And you can have a motion for a new trial or a motion for judgment NOV, which just means the jury got it so wrong. It's clear that the facts don't support their verdict, and so basically NOV means notwithstanding the verdict. All right, so once the trial's done, you're not done. You still have to get paid, because remember, money is what we're looking for in especially most civil cases. And so you've got to recover costs, attorney fees, whatever the verdict is. So there will be garnishment proceedings. There'll be proceedings to enforce the judgment. And that can be done through sheriff sales, or the sheriff going to the business at the close of day and getting whatever money's in the cash register, things like that. If it's an insurance case, then the insurance will usually write the check within 30 days. But if it's not, then getting paid can still be quite a process. Because trials are such a long process, and because everybody in the United States knows they have the right to sue, and so they like to do it, we've created alternative dispute resolution. The textbook has many different examples inside of it. I'm going to focus on two because these are the ones that you're most likely to run into in a business litigation environment. The first is arbitration. You really need to know the difference between arbitration and mediation. Arbitration is where you go before a third party who is not the judge. It may be a retired judge, someone who's an expert in the field, so like a medical attorney or something like that, but someone who's been practicing for a while and has a lot of experience. And they're neutral. They're not supposed to be on one side or the other. And usually the arbitrator's picked by each party submits like 3 or 4 that they would be willing to use. If there's a match, that's who it is. Otherwise, the judge just randomly picks, here's who your arbitrator is. And what they're going to do is they're going to hear the evidence and they're going to issue a binding decision. So when you go to arbitration, it's like a trial without a judge. This is why I don't like arbitration. If I'm going to have to take my chances on someone issuing a decision that we have to agree to and live by, I want a judge. I don't want an arbitrator. However, it's cheaper. And it's mandatory in some settings. It's becoming more and more a requirement in family law to have mediation or arbitration. And contracts often will require it. So that's something to watch for when you're signing a contract, is whether it allows you to go to trial or it's going to make you do arbitration. It's final. You don't get to go and have your trial if you don't like what happens in arbitration. So this is not my preferred method unless it's required by law or by the contract. Mediation, though, I have used, and I've used it strategically in a lot of different contexts. So here's why. Sometimes I'll have a client who's just not listening to me, and I'm trying to tell them, you need to settle. You're going to lose when you go to trial. This isn't going to go well. Let's cut your losses and let's mediate this. Or I have counsel on the other side who's being obstructionist. They're just not working with me for whatever reason. So this is one way I can try and talk to their client. Because once the client has an attorney, I have to talk to the attorney. I don't get to talk to the client. And so to their client. And so this is a way I can try and get around that. So I can educate my client, or I can educate the other side on here's what's really going to happen if we go to trial. So again, it's going to be someone who's been practicing for a while. They might be a retired attorney or judge, or they've got a lot of experience. We've got a couple mediators at the law firm I still practice with where they've become experts in family law. And so they're mediators in that area. And they've gone through training. It's like 20 or 40 hours of specialized training. They have to stay up to date on that training. And they serve as a go-between. You sit in a room at the beginning of the day, you put together a brief, here's what we think the law is, here's what we think will happen at trial. And then when everybody's seated at that table, you get a chance to tell the mediator what your side is, what you think is going to happen. And then they will separate you and you go into different rooms. And then the mediator goes back and forth between the two parties trying to reach an agreement. If they do, a settlement agreement will be drafted. The parties sign it, but then the judge still has to approve it. If mediation fails, then you still get your trial. All right, so that is the background for the court system, mediation, arbitration, and some of the background knowledge you need on the process to understand what we're going to go over as we start moving into substantive law.